that matter. She has advised myself that she's tied up in the court at the moment. So we have the trial matter of Brandy Martin. It's a self-rep trial.
Thank you.
She is present in the court.
Ms. Martin, you're having a trial today. The charge is that you've disobeyed a court order under the Children's Law Reform Act. Do you understand that? You've been in court in this matter perhaps 8 or 9 times already. The court date was set back in March. Does that ring a bell?
I remember when this trial was set.
Okay. Do you have pen and paper so you're able to assist yourself? And you can come forward. You don't have to be back there. You might as well come right forward.
I'm not going to be boarding your ship, so I'm going to stay here.
Beg your pardon?
I'm not going to be boarding your ship. That's what it's considered as
Uh-huh.
an unlawful, not detained person.
Well, you think you can hear from back there?
I can hear.
Okay, just a moment. You can stand up, please, because the charge is going to be read. And you can plead to the charge, guilty or not guilty.
Brandy Lynn Martin, you stand charged on or about the 21st day of June in the year 2012 at the Township of Tuscarora in said region did without lawful excuse disobey the lawful order made by the Honourable Justice Thibodeau, Ontario Court of Justice to Children's Law Reform Act, contrary to Section 127 of the Criminal Code of Canada. And how do you plead to this charge, guilty or not guilty?
I'm not going to be pleading.
The plea of not guilty will be entered on your behalf. If you want to have a seat there beside your friend, that's fine. You can make notes. If you can't hear what's being said, please let us know so that we can either speak louder or make some other arrangement. Crown ready to proceed?
Crown is ready to
Thank you. Call your first witness, please.
If I could first file or show Your Honor copies of the family court order. I'll show Ms. Martin as well. There are 2 orders.
Okay, and do you have copies for Ms. Martin?
I do. She has copies as well.
Okay. If I see correctly, one is July the 11th, 2011, is that correct?
That is correct.
The other is June 14th, 2012.
Ms. Martin, you have your copies of the court orders, family court orders?
Not here, no.
I'll show her.
Well, we'll do better than that. Madam Clerk, we can wait while you go on forward after those 2 orders, please.
Thank you.
Okay, I'd like to take the time right now to...
Just a moment until the clerk gets back. If you want to save your comments until the clerk gets back, we'll hear you, okay? Please have a seat. Please have a seat.
Thank you very much. Your Honor, if I may provide
Yes.
copies of these orders to Ms. Martin.
Maybe for the benefit of everybody concerned, can you indicate what paragraphs of the first order are alleged to have been breached?
Yes, sir.
That's the one of 11 July 2012.
That would be, you'll see that the applicants are Kobe Smith and James Smith. Paragraph 1, the applicants being Ms. Smith and Mr. Smith shall have custody of the children. Access in paragraph 2, unsupervised access was to be at a set time on Saturdays between 1 and 5.
Yes. So what's the alleged breach?
The alleged breach, as they relate to the disobeyed court order, is that Ms. Martin picked up the oldest child, Raylan, from school.
I actually object.
Just, well, I'll hear from you. We're hearing what the complaint is first, and then you can say whatever you wish to say about that. From school?
Yes,
On a date, particular day?
it was in mid-June of 2012, because the complaint wasn't made right away. It's
Can you
alleged.
see the information, please? Bear with me. Yes, the information alleges the 21st of June 12.
That's correct.
Does that make sense?
It does. From what I understand, a few weeks prior to that.
Well, it's okay. I don't want you to give evidence or summarize evidence. So that's the alleged breach.
Yes.
Is there anything else in that particular order that's alleged to have been breached?
No, nothing that jumped out at me when I...
Okay, then we move on to the next one, which is June 14, 2012.
This order was applied for by Ms. Smith, who had custody of the child after the child was removed from her care or picked up from school and not returned to her. She went to family court and got an order stating that the police could pick up the child or apprehend the child and deliver the child.
So what paragraph are we talking about? Paragraph 2, Roman numeral 2, page 2?
That's correct.
All right, let me read that. Yes, police enforcement of order.
Yes.
And what is the alleged breach, if any, there?
There's no alleged breach in relation to this order.
All right,
It's
I'll
the
make
July
a note
one.
of that. Okay, anything else to lay out the bare essentials for the charge, the Crown Seat?
No, sir. Just maybe the paragraph 1 of that order, the existing order for custody continues July.
Yes, the existing order was carried over.
Yes.
With a change in access.
That's correct. No, sir. Those are the relevant portions.
And that change of access now means supervised at the losing place access.
That's correct.
Okay, you wanted to say something?
Yes. What I have here is a motion to dismiss this case.
Sorry, I don't mean to interrupt. You're going to have to speak a little louder just so that goes recorded.
What I have in front of me, what I have for paperwork right here, is a motion, a notice of motion to dismiss, so I can give one to you, the ground person. And I'll have one for the judge, well, the court, I mean.
Would you rather like?
Sure.
And then I have my copy. Now, I'm going to going.
Have you notified the Crown of this before today?
Not before today.
Speaking no notice.
Right.
Before court started, I did. So this morning I did.
So if I understand correctly, the court date was set back in the spring, is that right? Today's court date was set back in March of 2013?
I don't have the record on me, but
Well, from your own memory, when do you think it was set?
prior to today. It doesn't matter to me, like I say yes,
But it does
on a
matter
previous
to me,
date,
so I
on
wanna
a
know
previous
what you
date,
think.
this,
I want to know what you
I'm not gonna
think
guess.
about when the date was set.
yeah, I'm not gonna guess. It's not good to guess at a date. So which date you have
That's
on
not-
file is
that's
fine.
not- Crown, when do you think the date was set?
Well, I believe the date was set last May.
See
There
what
was
you
a,
can find. May the 3rd?
yes, May the
Yes.
3rd.
The documentation before the court indicates that on May the 3rd, today's date was set for a one-day trial. Ms. Dover was there, but I think she was removed from the record at that time, so the matter was to go with or without counsel. That's the endorsement. Does that make sense to you?
Yes, it does.
And that's why Ms. Martin is here by herself without counsel. So was there some reason you couldn't bring the motion before today and give the Crown some notice about what your argument was going to be?
Yes,
What was that?
I didn't know that that was possible to do that, or that was a step to take.
Is there any affidavit attached to
No,
the
there isn't.
motion?
Okay, so I'm only under the authority of Creator. I retain all rights, and I don't consent to any of this. You have a fiduciary responsibility towards me, and I would like everyone to acknowledge that on record. Now, you have a motion in front of you for dismissal. I'd like it to be answered. And I, on and for the record, motion to dismiss this case.
Anything else you want to say about that issue?
Should I give, would you like any more like reasoning at all, or? Well,
Yes,
I'm fine for now.
that's correct.
Okay, this is something that just came to my attention recently.
Sorry, what is this something that came to your attention recently?
The Six Nations Police did not have jurisdiction or the courts because they did not have a binding contract between the Canadian government and the Crown from 2004 until March 2013, and that's why it should be dismissed.
Anything else?
Not at this time.
Does the Crown wish to respond to this argument now or not? And if not, do you want to have it put over to another date?
Crown is not prepared to respond to it at this time. And would be agreeable to having it go over to a further date to allow time to respond.
This matter is going to be adjourned because you brought this motion today without notice to anybody. It will be adjourned to a proper date that both of you can agree upon in order to give the Crown time to respond. I'm also going to give you time to put further documentation before the court if you choose to do so. It's up to you whether you do or not. So the endorsement, it's going to be lengthy, Madam Clerk. I'm not sure where you want to put it. Maybe on a separate sheet and staple it to the information. It'll be, of course, on the record anyway because this is a recorded event. There's a motion for lack of fundamental jurisdiction because the person in charge before the court claims there's a lack of jurisdiction because of her native status. The Crown only received notification of this today, the day of trial, a few minutes before trial. There is nothing in the material except as is indicated. The grounds for the motion are, quote, because it is my wish, end quote, which would be wholly unsatisfactory. I'm going to give the applicant moving on the motion time to put better and further material before the court, and of course give the Crown time to respond as well to either this material that's currently before the court or amended material as it may come in as per my order. It will be put over for a continuation of trial and argument of the motion in front of Me or a different judge, but I'm seized of it at the moment. So, the date is going to be sometime after April 1st. Madam Clerk, maybe we can get a date from the trial court there.
Would you like to keep it for this time?
Yes, if we can. Yeah, exactly.
Yeah, I'll call over and get started. Trial pointers are winning in, and I'll also get the deputy sergeant as well.
Thanks very much.
Now, before we set it to a date where you are going to be the presiding judge, I need you to acknowledge on record that you are going to uphold your fiduciary duty responsibility towards me.
I'm going to act as a judge of the Interior Court of Justice in a criminal court with respect to a criminal charge that's before the court and a motion brought with respect to that charge regarding jurisdiction.
And you're dealing with a North American Indian. So you have
I'm
a
aware that
fiduciary
you have-
responsibility towards me, and you have a responsibility to act as if though
Ma'am,
you were
if you don't
me.
give me a chance to talk, you won't know what I'm thinking. Do you want to give me a chance to talk? Yes or no? You have to say yes or no.
Yes.
I'm aware that you are a native person. I'm aware that you're bringing a motion before the court alleging lack of jurisdiction because of that fact, and it will be dealt with appropriately. I make no other commitment to you whatsoever.
Okay. Good to hear.
How many witnesses does the Crown have on this?
4.
4? We better make it for 2 days. This motion's going to take some time.
Thank you.
We're looking for 2 days, not 1.
Do you have your schedule for us?
It's very easy. Any day after April 1st except April 14th.
I could also check with the officer, could you just keep in conversation with the possibility members as well, please?
Any day the week of the 14th of April, could be the 14th, 15th, 16th, 17th.
Okay, why don't we try 14, 15 to start? Everybody okay with the 14th and 15th of April 2014?
15th, I'm sorry. 15th, I'm not available. I'll have a trial continuation on Justice April 10th.
Okay.
My apologies.
14th and 16th?
That would be.
14th and 16th. Sorry, did you say April 14th?
Yeah.
That's the one day I said we couldn't.
Oh, I'm sorry. Then 16th, 17th?
Yeah, 16, 17.
And I think the 18th is Good Friday, so that's agreeable.
16, 17. Everybody on board?
Yes, sir.
Okay. All right, this matter is adjourned to the 16th and 17th of April, 10 o'clock in the morning, courtroom number 5. The remand for Ms. Martin is to that 16th date, 10 o'clock in the morning, courtroom 5, 16th of April, for trial and motion. With respect to the motion, Ms. Martin will have a further 30 days to add any additional material she wishes to add to support her motion, such as an affidavit or written argument, whatever. And the Crown will have 90 days from today to respond to that material. And Ms. Martin will have 120 days from today to reply to that material. Because Ms. Martin is self-represented, I'll order a transcript for everybody, and the trial coordinator will eventually send a copy of the transcript of my order so that she can understand it to Ms. Martin. Do you have a current address, Ms. Martin, for mail?
Yes, it's the same address on the court
Same,
orders.
hasn't changed.
No, not for mailing.
Okay, that's great. That's all for today.
Thank you, I thank members.